Welcome friends to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today we will discuss an extremely important legal subject affecting millions of Indian families. Do daughters have inheritance rights in agricultural land? What have the Supreme Court and High Courts finally settled? What is the correct legal position in India as of 2026? This video is based strictly on verified judgments and settled constitutional law. Part 1: Why agricultural land succession was different. Historically, agricultural land in India followed a separate legal regime. Before modern reforms, personal laws governed family property. Agricultural land was controlled by state tenancy laws and customs. Many customary systems preferred male lineage succession. Important historical provision. Section 4(2) of the Hindu Succession Act, 1956 originally stated, the Act would not override state laws relating to agricultural land. Because of this, daughters were frequently excluded from agricultural inheritance. Part 2: Constitutional Transformation. The legal revolution began through Hindu Succession Amendment Act 2005. Parliament deleted Section 4(2). Introduced Section 6 Amendment. Created gender equality in Coparcenary property. Result: daughter became Coparcenary by birth. Equal rights with sons. Applies to ancestral property including agricultural land. This amendment is the foundation of all modern judgments. Part 3: Controlling Supreme Court judgments. These cases govern the law even today in 2026. 1. Vineeta Sharma vs. Rakesh Sharma. Supreme Court of India, reportable, constitutionally authoritative. Citation: 2020, 9 SCC 1. Bench Justice Arun Mishra, Justice S. Abdul Nazir and Justice Amar Shah. Decision date 11th August 2020. Issue: whether daughter becomes Coparcenary only if father was alive on 9th September 2005. Supreme Court held, daughter is Coparcenary by birth. Father's death before 2005 is irrelevant. Equal inheritance must be granted. Importance for agricultural land. After removal of Section 4(2), agricultural land cannot be denied to daughters merely because of old customs. This judgment presently controls all inheritance litigation. 2. Danamma at Suman Surpur vs. Amar. Reportable, citation, 2018, 3 SCC 343. Bench Justice A.K. Sikri and Justice Ashok Bhushan. Date 1st February 2018. Principle: daughters entitled to equal share in ancestral property even in pending partition matters. Practical effect: courts began granting daughters shares in rural agricultural properties. 3. Prakash vs. Fulvati. Reportable, citation, 2016, to SCC 36. Bench Justice A.K. Goyal and Justice Anil R. Dev. Decision 16th October 2015. Key rule: succession opens on date of death. If succession had already completed before statutory reform, later amendment may not reopen it. This explains why some high courts still deny claims in very old agricultural disputes. 4. Uttam vs. Saubhag Singh. Reportable, citation, 2016, 4 SCC 68. Bench Justice R.F. Nariman and Justice Amitava Roy. Important clarification: property inherited under Section 8 Hindu Succession Act becomes self-acquired property of the heir. Impact on women: a daughter inheriting agricultural land becomes absolute owner, not limited holder. 5. Ganduri Koteshwaramma vs. Chakiri Yandi. Reportable, citation, 2011, 9 SCC 788. Held, even after preliminary decree in partition, daughters must receive amended shares under the 2005 amendment. This strengthened women's rights in pending agricultural land partitions. 6. Madhu Kishwar vs. State of Bihar. Reportable, citation, 1996, 5 SCC 125. Principle: Hindu Succession Act does not automatically apply to scheduled tribes. Continuing position, 2026. In tribal agricultural land, customary law may still govern succession. Equality claims require constitutional scrutiny or legislative action. Part 4. True legal position regarding agricultural land, after 2005. From the binding principles laid down by the Supreme Court and consistently followed by high courts across India, the modern legal position relating to women's inheritance in agricultural land has now become substantially settled. Each rule is explained below in detail for clear legal understanding. Rule 1. Daughter is Coparcenary by birth, equal status with son. After the Hindu Succession Amendment Act 2005, a daughter is treated as a Coparcenary from the moment of birth, exactly like a son in a Hindu joint family governed by Mitakshara law. This means that her right does not arise because of marriage, death of father, or family consent. The right exists independently by operation of law. A Coparcenary enjoys three important rights: right to demand partition, right to joint possession, right to claim equal share in ancestral property. Therefore, agricultural land forming part of ancestral or joint family property must be divided by giving daughters the same share as sons. The law no longer recognizes the earlier social assumption that agricultural property belongs primarily to male members engaged in cultivation. Even if the daughter never lived in the village, never cultivated land, or was married long ago, her legal status as Coparcenary remains intact. Rule 2. Agricultural land is included within inheritance rights. Historically, agricultural land was treated differently because earlier law allowed state tenancy statutes and customary rules to override succession law. This resulted in widespread exclusion of women from agricultural property. However, after deletion of Section 4(2) in 2005, the Hindu Succession Act obtained overriding effect over most agricultural land succession disputes. The practical consequence is extremely important. Agricultural land is now treated at par with other immovable property. Gender discrimination based solely on the nature of land is legally unsustainable. Revenue authorities cannot deny mutation merely because the claimant is a daughter. Courts today proceed on the presumption that agricultural land forms part of inheritable property, unless a specific statutory exception applies. Thus, the earlier distinction between house property inheritance and agricultural land inheritance has largely disappeared in modern jurisprudence. Rule 3. Marriage of daughter is legally irrelevant. One of the most common misconceptions in rural property disputes is that a daughter loses her inheritance rights after marriage. Modern law completely rejects this notion. Marriage does not terminate. Coparcenary status, succession rights, ownership entitlement. A married daughter continues to remain a member of her natal family for inheritance purposes. Her relocation to another household does not divest her legal rights. Courts have repeatedly clarified that inheritance rights are not dependent upon residence, dependency, or contribution to cultivation. Therefore, a married daughter, a divorced daughter, a widowed daughter, all stand on equal legal footing with sons while claiming agricultural land. Rule 4. Date of death of property owner still plays a crucial role. Although equality principles now dominate succession law, courts still apply a very important technical rule: succession opens on the date of death of the property owner. If succession had already legally concluded under the law existing at that time, later statutory amendments may not reopen settled inheritance. For example, if a landholder died decades before modern reforms, property devolved according to then existing law, shares crystallized and were acted upon, courts may refuse to disturb completed succession. This principle ensures legal certainty and prevents reopening of extremely old family settlements. Hence, while modern law is progressive, historical timelines remain legally significant in agricultural inheritance litigation. Rule 5. Change in nature of property after inheritance under Section 8. Another important legal principle concerns the character of property after inheritance. When agricultural land devolves upon heirs under Section 8 of the Hindu Succession Act, succession after death of a person leaving separate property, the property ceases to remain joint family or ancestral property in the hands of the heir. It becomes the self-acquired property of the person who inherits it. This has major consequences. The heir becomes absolute owner. Future generations do not automatically acquire coparcenary rights. The inheriting daughter obtains full ownership powers, including sale, transfer, gift, or will. Thus, modern law strengthens women's economic autonomy by converting inherited agricultural land into their independent property. Rule 6. Tribal and customary law exception. Despite wide expansion of equality principles, Indian succession law recognizes limited exceptions relating to scheduled tribe communities. In certain tribal regions, customary inheritance systems may continue to operate. The Hindu Succession Act does not automatically apply unless specifically extended by legislation or judicial interpretation. Therefore, inheritance of agricultural land among scheduled tribes may depend upon recognized tribal customs, regional statutory provisions, constitutional examination by courts. However, even in such cases, courts increasingly examine whether customs violate constitutional guarantees of equality and dignity. This area of law continues to evolve gradually toward gender justice while balancing cultural autonomy. Final legal position. After 2005 reforms and subsequent judicial interpretation, daughters are equal coparcenaries. Agricultural land is ordinarily inheritable by women. Marriage does not affect inheritance. Historical succession timelines remain relevant. Inherited property may become self-acquired. Limited customary exceptions survive. Together, these principles represent the modern constitutional approach toward women's property rights in India. Part 5. High Court Trends, 2023 to 2026. High courts across India are consistently applying Supreme Court principles. Observed judicial trends. Revenue authorities cannot deny mutation to daughters. Gender discrimination in agricultural inheritance is discouraged. Courts insist on proof of valid partition or will. Old oral family arrangements are strictly scrutinized. Women excluded earlier are approaching courts successfully. Important clarification. Many so-called 2026 landmark judgments circulating on YouTube are not new law. High courts are simply implementing Vineeta Sharma principles. Part 6. Frequent legal questions. Can a married daughter claim agricultural land? Yes. Does cultivation by sons alone defeat daughters' rights? No. Does mutation entry give ownership? No. Only fiscal record. Can daughter challenge old will? Yes, if execution not proved under Evidence Act. Part 7. Practical steps for women claiming agricultural land. 1. Obtain death certificate. 2. Check record of rights 7 to 12 extract. 3. Identify ancestral or self-acquired character. 4. Verify whether partition occurred legally. 5. Challenge illegal mutation immediately. 6. File partition or declaration suit. Part 8. Most important legal warning. There is no new 2026 Supreme Court judgment newly granting daughters agricultural land rights. The real legal revolution already happened through 2005 Amendment. Vineeta Sharma Judgment. Courts today are enforcing equality, not creating new law. Conclusion. The modern Indian legal position is clear. Women have equal inheritance rights. Agricultural land is no longer male-exclusive property. Constitutional equality now governs succession. Understanding these principles prevents decades of family litigation. Thank you for watching. If you found this video helpful, please like, subscribe, and press the bell icon for more legal insights. You may also join this channel by clicking the join button below this video and support my efforts in spreading legal awareness among citizens. Jai Hind! Jai Bharat!